think we might make a start at this point. Look, I'm Sarah Murray, and I'd like to welcome you all on behalf of the Australian Academy of Law and the WA chapter of the Australian Association of Constitutional Law. And the seminar that we're lucky to have tonight, Australian Federalism in the Time of COVID. I just asked who are joining if you could just keep your microphones muted, just so we're not getting too much interference. I'd like to start by acknowledging that I'm coming to you today from Whadjuk Noongar land, and that the Whadjuk people of the Noongar Nation are the traditional owners and the spiritual and cultural custodians of their land. I respect to their elders, present and emerging, and I acknowledge their languages, legal systems and knowledges, all of the Uluru Statement from the heart. I'd like now to invite you all to use the chat function on Teams, which you should be able to find at the top, to acknowledge the land from which you're all joining us from. And this is a lovely opportunity, considering we're all joining from near and far.
Don't know how to do it. And I don't know whose land this is down here. I think it's yeah, it's the Budgie people, I think.
Yeah.
Just a couple of housekeeping things while people are doing that. I just want to let you know the event is being recorded, and after the seminar, it'll be placed on the Australian Academy of Law website. I just ask that you keep your microphones muted when you're not speaking, just to stop any potential interference while it is being recorded. Although I see that we have quite sneakily snuck this event in on the last day of the WA CPD cycle, I just want to make sure that attendees with a WA practicing certificate know that this is not an approved event for CPD purposes, just in case anyone thought it might be. I somehow feel that we've spent the last 3 years, desperately looking for silver linings, silver linings, beyond some of our newfound technical abilities that allow us to hold events like this, but even allow us to, to continue searching, I guess, for, what is coming out of our experience of the pandemic that may not be all bad. Are we able to look at our COVID-19 experience so far and see whether to some extent it's revived or even contributed to a revival of Australian federalism? What is the landscape of Australian federalism today? How robust has it proved to be? What can we draw from the dynamics of the rather misnamed National Cabinet? Have states been able to flex their muscles to a greater degree? Certainly in WA, there's been all sorts of wax it, chest beating, even more than the normal clamour. And what I'm really hoping that we can get from the seminar this evening is what we've learned about our crisis decision making and what patterns we're beginning to see. And to read the tea leaves for our federation in this context, I'd like to welcome Professors Alan Fenner and Nicholas Aroni, who we're very, very, very fortunate to have with us this evening. I'd first like to invite Professor Fenner to speak to us. Professor Alan Fenner works across the areas of Australian government and politics, Australian public policy, and Australian and comparative federalism. He's based at the John Curtin Institute of Public Policy in Western Australia. He's the author of a broad range of works and was recently part of an international research project on centralising dynamics in federal systems. He's penned a number of pieces on our COVID trajectory and how this is compared with other federations. And we're very lucky to have him with us today to share his insights. Thank you very much, Alan.
Thank you, Sarah. Am I coming over loud and clear?
Yes, absolutely.
Silver linings. I think that was a great choice of words here, and I'll certainly be talking about silver linings. And I think Nick and I will have a very nice division of labour with what we're doing. I'll give my take on a broad overview of the federal system in both international context, temporal context, and how we situate current developments in that context. So the broad lie of the land, and hopefully that opens up some questions about interpretation and judgment about the relationship between the levels of government and the degrees of how the two have operated together. While Nick will then focus in on to some very specific technical questions that are far beyond my competence. So the starting point has to be for any of this sort of discussion, apropos of the silver linings, has to be the fact that over the last decades, two general aspersions have been cast on Australian federalism repeatedly. It's really been the main themes of how Australian federalism has been discussed, probably both academically and more politically. One is that it's highly dysfunctional in various ways, and the other is that it's become hopelessly centralized. So the dysfunctionality is a sort of encapsulating notion for a range of criticisms that have been currently made about overlap and duplication between the Commonwealth and the states, about balkanization, breaking up the flow of people, goods, and so on across the country, about blame shifting in service delivery failures, and a variety of other ways in which the Federation has been seen as essentially a burden on both society and governance. The states, meanwhile, have been seen often pictured as being mired in incompetence and as constantly importuning the Commonwealth for funds, as somehow unable to be responsible for their own fates in many ways. Think, for instance, of the notorious comment by Keating, either before he was Prime Minister or when he was Prime Minister, about never get between a premier and a bucket of money. This sort of dismissive attitude about the place of the states in the federal system, or from the other side of politics, Tony Abbott, when he was in the Howard ministry, his description of it as feral federalism, that the states had really passed their use-by date in many ways, which was particularly ironic coming from, of course, a party that had stood loyally behind federalism for many years for reasons that we can't discuss here, but are clearly explicable. So that dysfunctionality has been a recurrent theme over the last 20, 30, 40 years at least. And the other one has been observations about the seemingly ineluctable process of centralisation, whereby the Commonwealth has taken on more and more responsibilities, assumed a greater directive role vis-a-vis the states in their own areas of responsibility. And as a nice way of encapsulating it, I rather like the title of a piece that Robert French, erstwhile Chief Justice of the High Court, wrote for a special issue I put together some years ago, which he called "The Incredible Shrinking Federation: Voyage to a Singular State?" ? And I can't remember whether the end of the paper answered the question, but it's certainly the thrust of the implication was clear. And this comes to something that Sarah mentioned at the beginning that I've been involved in, which was an international comparative project assessing how major federations have travelled since their foundation. And that, of course, goes back a long time in the case of the United States, much less so in the case of Germany, but for a number of federations over their entire duration, how have they travelled? And the general conclusion from that was that they, with one significant exception, have become enormously more centralised over that period, and that Australia is a prime example of that process at work. And we published that as a special issue of the journal Publius in 2019, and had with assessments of each individual case plus conclusions about how they compared. And so, as I say, the general trend was highly centralising, and certainly Australia was exemplified that process. So centralisation has indeed been, by most measures, been occurring at a formidable pace in Australian federalism. And those modes of centralisation have included an expansive interpretation of the Commonwealth's enumerated powers. The most dramatic recent one, not having occurred for some time, but would be the work choices case. Fiscal centralisation and Australia's very, very unusually high degree of vertical fiscal imbalance, with the Commonwealth raising 80% of all tax revenue in Australia, and the states being reliant on the Commonwealth for up to 50% of their revenue. The aggressive use of the spending power to intervene in areas of state jurisdiction through conditional grants, plus as well a number of areas where more consensual centralisation has taken place, including a referral of powers, rare but not insignificant over the last few decades. So various modes of centralisation all have contributed to that general trend, all been part of that general trend. It has been easy to forget, observing all that, it's been easy to forget that the states still are important nonetheless, because they seem to have lost so much independence, particularly fiscal independence. But it never was the end of the states, for a number of reasons. One is, which of course is they do a lot that doesn't require fiscal instruments. They have a large regulatory role. Secondly, they exercise some, perhaps considerable implementational discretion in what they do with funds that are given to them conditionally. And thirdly, they still carry out by far the largest part of the day-to-day governance tasks, quotidian and otherwise, in running all the main public services. So the states continued being tremendously important while the system greatly centralised. Why did this centralisation occur? Well, essentially, modernity has not been kind to federalism. The classic federations, the original federations, were all founded in periods when almost all functions were seen as and were inherently local in nature, and that, of course, has changed enormously over a century or so. Whether it's in fields of economics, whether it's in social policy and tax policy, whether it's in things like human rights, concepts that didn't even exist when these federations were founded. So modernization has not been kind to federalism at all. It has made much of what is local essentially national and indeed international. So that's the context for what's occurred recently, which we could call the recrudescence of the states, though it's partly a recrudescence and it's partly just reminding us of the continuing important role that the states play. So there's been recent developments that have been much kinder to federalism in Australia than much of what occurred over the 20th century, for instance. Two of them stand out in particular, and one of them has been climate change politics, and the other's been the pandemic. And both of these have contributed to a recrudescence of the states, and for some people, a quite surprising revival of the states. So in the case of climate change, I think we could describe it as a process of compensatory federalism, whereby one order of government is able to compensate for a failure or inaction at another level. And that this is not unique to Australia. Interestingly enough, this has been quite a broad trend across federal systems where, particularly the United States, where the central government is unwilling or unable to take action, and many of the states step up to fill in for that inaction. So in Australia, the states have definitely led the way, given the dominance of the coalition and its position on maintaining Australia's reliance on traditional energy sources, and that sort of partisan dynamic at the Commonwealth level. The states have, since about 2000, played a strong assertive role in climate change policy, compensating for partisan inaction at the Commonwealth level. Jointly and individually, they've developed and implemented a range of programs and policies to bring about, in particular, a transition, the energy transition from a reliance on coal and fossil fuels more broadly, to renewables for the generation of electricity, which is the single largest producer of Australian greenhouse gases. So I think it's very, very clear that has the states have played a major role in that respect, and in turn that has given the states a stronger raison d'etre and a greater prominence politically. The big difference perhaps between Australia and some of the other countries in this respect is that it has been much more broadly across the states, whereas, for instance, in the United States, some states have taken a very strong leadership role and others have maintained a very strong tie to traditional fossil fuels instead. And the second one is, of course, the topic of the day, which is the pandemic. And it's interesting here to think back to the sort of 5 minutes before the pandemic started. And the big issue there, the big crisis we faced then was the bushfires, which was seen as catastrophic, seen as another one of these once in a 100 years events, and raised questions about the functioning of Australian federalism, in particular because bushfires so readily cross state borders, and having state-based emergency systems didn't seem entirely up to the task of managing them most effectively. And the Prime Minister responded by raising questions about whether the Commonwealth should give itself greater emergency powers. And there was a Royal Commission which suggested that should be the case because the states were failing in this respect, because like many other things in the federal system, the problem was it crossed state boundaries too much. So the difference with COVID couldn't be more obvious. From the beginning, the states stepped up effectively. The Commonwealth, I mean, one could almost imagine the Commonwealth not being in the picture at all in the way that the pandemic was managed. And this is the difference in how this appeared and operated, I think, comes back to a number of features about the pandemic in particular, about a problem of that nature in general. One of which, of course, concerned governance matters almost entirely, with the exception perhaps of quarantine, almost entirely within the normal day-to-day responsibilities of the states: schooling, shop hours, rules about shops opening, and so on. The second is that borders worked all of a sudden. Bushfires ignore borders, but the virus can't, because the virus has to be transported by human beings. So the virus can't ignore borders, and all of a sudden, the balkanization that had been so much criticized, particularly by business through the 90s, when they were pushing for the seamless national economy, the balkanization that had been deplored on a variety of fronts for a variety of years became a very useful instrument in controlling this particular problem. So the disadvantages of federalism were turned on its head in that respect. Thirdly, is the way that it varied enormously from region to region, which gives something for which federalism is particularly well designed to manage. And so locally appropriate and politically supported measures in tune with local populations could be implemented. Another factor I think is important there is that managing the pandemic in Australia was primarily a regulatory task. The fact that the states are perennial paupers, with the exception perhaps of one, wasn't so important when the major instruments were regulatory rather than fiscal, particularly when the fiscal dimension of the crisis, which is undeniable, could be left safely to the Commonwealth. So the states could proceed very well using their indisputable regulatory powers in those respects. And then there was the final element, which was the degree of successful cooperation between the Commonwealth and the states. And there were always frictions and always conflicts at some level, but But by comparison with the past and by comparison with other federations, the level of coordination was optimal. I've called it loose coordination, meaning not that everyone agreed to do the same thing, but that everyone agreed on a general roadmap and a general approach and general sets of definitions and rules, and then played it from there. And this was too loose a form of coordination for some, and particularly when the Commonwealth disagreed with the rather prophylactic, or what they saw as an excessively prophylactic approach taken by the states. But I think by many people's measures, it was an optimal degree of coordination and alignment that worked through National Cabinet. Now, National Cabinet is sometimes projected or seen as a major innovation, but I think it could be seen rather as a adaptation, and one that occurred very quickly, to a set of conditions specific to these times and worked very well for those circumstances. So on the whole then, what we're seeing here is two types of events that have been much kinder to federalism than much of what occurred in the 20th century, and why we're both appreciating the role of the states more and why the states actually do have more of a role of the states, more of a role in the federation. But the moral of the story is that all these things are contingent upon what issues and events and general broader changes the federal system is confronted with. These happen to be the major challenges of the last couple of decades, but there'll be different ones in the future, and the system will again respond accordingly. So, I mean, one conclusion from there, I think it has to be that the federal system is highly contingent in that respect and quite flexible in that respect. So the silver lining is there, but it doesn't mean that there's a permanent redirection in the trend of Australian federalism. So I will pass the baton to Nick to fill in any of the many gaps and look at some of the finer detail, particularly vis-a-vis things like the use of the border closures.
Thank you very much, Alan. That's a really, really helpful introduction to set us off. And I really love the idea of thinking about sort of the recrudescence of the states and this idea of, you know, how we've always talked, as you say, about kind of how federalism is all about allowing for difference and how that dynamism has really come to the fore with COVID. So a really fascinating start. Now, I'd now like to invite Professor Nicholas Aroney to speak to us. He's a Professor of Constitutional Law and a Fellow of the Centre for Public, International and Comparative Law at the University of Queensland. He's held many visiting positions, including at Oxford, Cambridge, Paris, Edinburgh, Tilburg universities. He was recently awarded an ARC Discovery Grant looking at constituent power in federal constitutions, and he's written enough books and works on federalism to fill many a bookcase. So please join me in welcoming Professor Aroney.
Thank you very much, Sarah, and I hope everybody can hear me okay. So that was great to have that overview from Alan, and what I'm going to try and do is focus perhaps a little more specifically on some of the legal dimensions of the state and federal and even local government interaction through the COVID crisis. And I think that it seems to me that now that we seem to be returning to an almost normal situation, we do have an opportunity to reflect, and I hope rationally, on our government responses to the crisis, as well as the statutory and policy frameworks in which decisions have been made. I worked on a title for this paper, and I called it The Hedgehog, the Fox and the Australian Federation, and subtitled it Decision-Making Rules in a Public Health Crisis. Why did I choose this title? I'd explain it in this way. The fundamental question of federalism can be described as one of unity vis-a-vis diversity. When, how and why does the system facilitate a unified policy response, and when, how and why does it facilitate a diverse set of policy responses? This question of unity vis-a-vis diversity also arises in the relationship between the public and the private, and the collective and the individual. So when it comes to, say, an issue like health and well-being, what weight do we give to the general interests of public health vis-a-vis the particular health and well-being of each individual? Do we adopt a Benthamite utilitarian calculus in which the cardinal principle is one of securing the greatest good for the greatest number? Or do we adopt something more like a Kantian deontological approach in which each individual is treated as an end in themselves and whose welfare and autonomy is never to be deliberately prejudiced for the benefit of others? Regarding the medical profession, considered broadly, what weight do we place on the judgments of public health officials vis-a-vis the judgments of individual clinicians whose concern is the health and well-being of their individual patients? I think a lot of the policy debates about how best to respond to the crisis have been shaped by underlying evaluative frameworks of these kinds. In the language of Isaiah Berlin, while the fox knows many things, the hedgehog knows one big thing. Some of us are foxes and others of us are hedgehogs. Some of us consider that allowing a diversity of approaches to a complex array of problems is more likely to help us secure the best outcomes, while others of us are inclined to the adoption of unified national plans. Do we favour an approach that is simple, singular, and universally applied to an array of approaches that are complex, plural, and specifically tailored? On these sorts of issues, I think personally I'm more of a fox than a hedgehog, but I recognise that some of you may well be hedgehogs. My colleague Alan Fenner, and I make no comment on whether he's a fox or a hedgehog, has taken you through some of the dimensions and the context of Australian federalism that I think has been very illuminating. And what his and other analyses demonstrate is that our federal system has responded quite effectively to the crisis, at least in relative terms compared to some other federations in the world, and has maintained significant elements of both unity and diversity in the policy response. However, I think if we were to focus our attention on each state in particular, it would have to be concluded that many of our state governments have themselves adopted the perspective of the hedgehog rather than the fox as regards their own domestic state policies. This is no doubt largely a consequence of politics and political ideology, as the differences in approach adopted by the various states suggest. But I want to propose that it is also the consequence of the way in which the public health acts in the states and territories are constructed. When one surveys the territory responses and the state responses, one can identify interesting differences with respect to things like who is the decision maker? Is it political? Is it a responsible minister? Or is it a professional chief health officer? And also an important question is what expertise is brought to bear from that professional point of view? Is it the expertise of public health? Is it the expertise of clinical medical issues? And how do questions that are of more social nature, psychological nature, economic, legal or ethical nature enter into decisions about policy responses to a public health crisis? And that all overlays into the point I'm making about the hedgehog and the fox, about whether we approach these questions from a predominantly collective public health point of view, or are concerned also about the individual medical needs, preferences of individuals and their autonomy and their freedom. And I also think that another important factor here has to do with one's appetite for risk and the appetite for risk that our political leaders have. I think it is clear that some people have more risk-averse personalities, while other people are more willing to embrace risk, at least more readily than others. And yet it seems to me that despite this variation, one thing's abundantly clear, and that is that the public health acts in the states confer enormous regulatory powers on public health officials and responsible ministers once a public health emergency has been declared, and we've seen that so very clearly. Given these enormous powers, I think there are real questions about accountability and transparency. What are the role of the parliaments in all of this? What is the role of parliamentary committees? To what extent do freedom of information laws require disclosure effectively of important information? I think the Australian states and the Commonwealth entered the COVID crisis relatively well prepared compared to some countries. Legislation existed conferring considerable powers, as I've described. And written policies existed to try to coordinate the contributions of the various departments and agencies at a federal and state level, even though a lot had to be done and there was a lot of scrambling that was done in the early months and first year of the crisis. But while not wishing to be understood in any way minimising the seriousness of COVID-19, these legislative and policy settings were established with the most severe of life-threatening pandemics in mind. Or to put it slightly differently, the legislative and policy frameworks were designed to enable governments to address pandemics of varying severity, varying scale and varying complexity. Because pandemics can involve pathogens of different contagiousness, morbidity and mortality. And in each of these respects, the mortality and the morbidity of the disease can be more or less uniformly spread across the population, and particular groups of people can be more or less particularly susceptible. Now, I don't wish to get into a debate about these matters in this forum, and we know that they have been matters of heated debate in the community, but I do want to point out that these questions are important and that our legislative and policy settings need to be adaptable to the particular characteristics of each disease, so that the effectiveness of our response can be maximised. So to dig into these issues just a little more deeply, and I'm conscious that I've raised quite an array of issues in what I've already said, in the remainder of my presentation, I want to focus on two interesting examples of mostly legal issues that have arisen in connection with the crisis. The first concerns something about the background and perhaps a little known set of facts about Clive Palmer's failed challenge to WA's border controls a couple of years ago. And the second one concerns some problems that I think may possibly exist about the privacy protections built into the Commonwealth's immunisation register, which seem to have been not properly dealt with by the states. So let me start with the Clive Palmer case. Now, as I'm sure most of you, probably all of you know, that the case was initiated by Mr. Palmer in response to the closure of the WA state border. And he argued that the closure was unconstitutional because it restricted freedom of interstate trade and commerce, as well as interstate intercourse, that is, freedom of personal movement between the states. And constitutional lawyers have had a field day discussing the approach taken by the court. And the court did indeed take the opportunity to clarify the tests to be applied and confirmed that freedom of personal movement between the states can be restricted, but only if the limitation is reasonably capable of being considered appropriate and adapted to achieving a legitimate purpose, and that this involves a close assessment of the suitability, the necessity and the balanced nature of the intervention. In the upshot, the court held that the border closure in WA met these tests. But importantly, much of this conclusion depended upon the state of knowledge at the time the case came before the court. And at that time, the modes of transmission of the disease were not well understood, and the effectiveness of various control measures were as yet untested. The court has very limited capacity to receive evidence in cases where the facts of the matter are crucial to the determination of the case, and so not infrequently, such matters are remitted to a judge of a federal court to hear evidence and make determinations of fact. And this is what happened in Palmer's case. The matter was referred to Justice Rangier of the federal court. As one reads His Honour's judgment, 5 things stand out, at least to my mind. The first is that WA seems to have won a tactical battle in its choice of scientific and medical experts. Based on the evidence before him, Justice Rangier formed the view that WA's experts, and one in particular, had the most specific knowledge and understanding of the particular scientific and medical issues relevant to determining the proportionality of WA's border closure. The second is that that particular expert relied upon a journal article which offered a very specific method of approaching health pandemics in terms of determining their significance, especially their contagiousness and their severity. Now, I have to admit that this got me curious, and I dug up a copy of the journal article, and what I found was interesting. And it has some features that I don't think emerge from simply a reading of Justice Rangier's judgment. The conclusions that the expert and the judge arrived at on the basis of the framework proposed in the article was that the disease had 5 characteristics. It spread from human to humans in a way that the whole population was genuinely susceptible. It caused severe disease. a significant number of people would be affected, it was highly infectious, and effective interventions were not available. By answering yes to each of these, as it were, questions, the expert concluded that on a scale of severity, which assesses the seriousness of the disease from minimal, low, moderate, high to very high, the disease posed a very high, indeed the very highest level of impact on human health possible. What was not explicitly explained in Justice Rangier's judgment, however, was that this algorithm contained within itself very vague categories involving questions of degree and judgment that were not specified by the journal authors themselves, the authors of the article themselves. Thus, there was no scale for the determination of the severity of the disease offered in the article, no specific criteria, and there was no scale given for the assessment of whether a significant number of people would be affected. Significance of the number was not defined, and the article candidly acknowledged this. As a consequence, the application of the algorithm to what was known of COVID-19 at the time resulted in its classification at the very highest level of seriousness. So as I've said, while I don't want to be understood as downplaying the seriousness of COVID-19, it seems to me just, if I may say so, a little odd that it should receive the very highest rating possible against a scale which is meant to incorporate the assessment of diseases that can come across at a very wide range of severities, and noting that there are some diseases that are widely acknowledged to be even significantly more lethal for a significantly larger proportion of the population and just as contagious as COVID-19, and fortunately are just contained at this time. Or at least, even if there aren't any in existence at the moment, a scale like this needs to take or to be able to assess a disease that is that serious. In this context, the third important feature of Justice Rangier's judgment comes into play, I think, which is that given the potentially catastrophic, although strictly as then yet unknown, potential impacts of the disease, a precautionary approach was justified. This helps to place the wider significance of the judgment into perspective. For now that we have more knowledge about the spread and severity of the disease, as well as its treatment and prevention, or at least reduction in severity through vaccines, a legal challenge to any future border closure would raise fresh and as yet untested factual questions, thus leaving the resolution of any such case an open matter, I think. Fourthly, Justice Rangier was explicit that his conclusions were based on public health and epidemiological considerations and did not take into account economic, social, or individual impacts. Even though his findings of fact were limited in this way, this did not seem to arise as an issue before the High Court, although one would have thought that an assessment of the proportionality of a government measure would depend on an assessment of all of its impacts and not just its particular consequences for public health. However, one can also understand the reticence of the courts in trying to second-guess policy decisions of these kinds, given their enormous factual complexity as well as normative difficulty. And this brings me to the fifth observation, and that is that Palmer's fate was virtually sealed by the findings of Justice Rangier, for it would have been very difficult for the High Court to conclude against the WA government in the light of these factual conclusions. The second issue I want to touch on before I close this evening is to look at the interface between Commonwealth and state laws. And I want to focus here on a particular issue, namely the vaccination information contained in the Commonwealth's Immunisation Register. The Commonwealth's Australian Immunisation Register Act of 2015 establishes an immunisation register which records the vaccination status of Australian citizens. The information is recorded in the register as supplied by vaccination providers, like general practitioners, who are now required to report information about the administration of vaccines. This information held on the register includes, among other things, identifying information about the individual, their name, contact details, date of birth, gender and Indigenous status, information about the vaccination, including what vaccines have been administered and the date of any vaccination, as well as information about any assessment of an individual as to whether they do not require vaccination because they've contracted a particular disease or have developed a natural immunity, or as to whether they have a medical contraindication to vaccination. Notice the significance of this information from the perspective of the privacy of each individual in relation to their medical and health related matters. The Commonwealth Act describes its purpose in specific terms. These purposes include record keeping and statistical research, monitoring, particularly to identify people at risk during disease outbreaks, promoting individuals' health and well-being, checking an individual's vaccination status, certifying when a course of vaccination has been completed, and anything incidental to these purposes. Notice that none of these purposes specifically contemplate the use of the vaccination information for wider public health purposes, such as prohibiting entry of unvaccinated persons into places of business in order to minimise the spread of a disease. In order to protect the privacy interests of individuals whose medical records are kept on the register, the Commonwealth Act makes it an offence, publishable by up to 2 years of imprisonment, to record, disclose or otherwise use protected information on the register dealing with a person's personal records. When the Commonwealth Act was amended in 2021 to require vaccination providers to report vaccinations, it was expressly noted that the privacy protections in the Act would remain fully intact. This criminal prohibition on disclosure of protected information does not apply, it needs to be noted, if the disclosure is in accordance with the express or implied consent of the person to whom the information relates. So if a person discloses their own vaccination status to a business owner or employer for the purpose of gaining access to the business or continuing their employment, there is a question whether there is consent, if the context suggests the disclosure has occurred in circumstances where its voluntariness was compromised. Moreover, while a person may consent to the disclosure of their vaccination status to the business owner or employer, they may not have consented to its disclosure to other persons. The Commonwealth Act specifies a range of circumstances where disclosure or use is authorised and therefore not unlawful, including where a person is required or authorised to do so under a law of a state or territory. Now, this is where the interface with state and territory laws comes into the picture. Now, in this paper and my presentation, I'm briefly, in conclusion, going to use directions issued by the Chief Health Officer of the Northern Territory as an illustration. Under the Northern Territory law, the Chief Health Officer may, when an emergency declaration is enforced, take actions and issue directions he or she considers necessary or appropriate or desirable to alleviate the public health emergency. And these can include segregating and isolating persons and prohibiting them from entering certain places and requiring them to remain in a certain place and so forth. Under a direction issued on the 10th of January this year, the Chief Health Officer required every person in authority in a place of business to take reasonable steps to ensure that no member of the public enters the place of business without providing evidence of vaccination or a contraindication to vaccination. Recognising that this meant in practice reliance on evidence drawn from the Commonwealth's immunisation register, and that provision of such evidence would involve disclosure of protected information, the directions expressly authorised any such person in authority to request and collect immunisation information, so as to capture that exemption, as it were, under the Commonwealth law. Notably, though, this authorisation extends only to requesting and collecting the information. It does not authorise its use or its disclosure to any other person. The direction further requires the person in authority to destroy any relevant documentation as soon as practicable and at least within 48 hours, and requires them to assure that it's secured against access by any person for non-lawful purposes. Contrary to the Commonwealth Act, it appears that the vaccination status of numerous people has in fact been disclosed publicly from time to time, such as in newspaper reports, including within the Northern Territory. It is also the case that the vaccination status of any person who obtains access to a place of business or is refused access will in effect be disclosed to everyone who is present to observe it, and there will be no preventing those persons from disclosing this information among their friends, relatives and work colleagues. Now, the Northern Territory seems to have been more careful in this matter than at least some other subnational jurisdictions. I've only had time to have a look at Queensland, but I confess I can find no reference in Queensland law specifically authorising the use of protected information by business owners under the vaccination mandate laws in operation in that state. I stand to be corrected if I've overlooked something, but I can't find it. Privacy protections such as those contained in the Commonwealth Act were established to settle as a matter of principle that a person's medical condition or status must be kept in confidence and only disclosed under specific circumstances and for specific purposes. Like Ulysses' decision to strap himself to the mast of his ship lest he be seduced by the sirens, these provisions were enacted in advance to ensure that fundamental human rights would not be overlooked or interfered with in the midst of a public health crisis. However, it seems that these laws have operated more in the nature of what James Madison called parchment barriers. And I could say a few things about what Madison had to say about this, because in one of his important essays in the Federalist Papers, he observed that parchment barriers, which are merely things written on paper in the form of statutes or constitutions, don't always have an effect and are not always able to prevent a sort of gradual accretion of power, particularly when the executive has an opportunity to exercise power. And he doubted the effectiveness of parchment barriers when those pressures existed. I think his words are prescient. In a recent article published in the Australian Medical Journal, the authors called for changes to the immunisation register so that it could include data enabling identification of at-risk individuals. Exceptionally good reasons were given in the article for the expansion of the register. They said that there would be benefits at both a population and at an individual level, and you can see how that would be the case. But what is noticeable about the article from a legal and ethical perspective is the casual and frequent use of the term surveillance to describe the essential function of the register, as if this does not pose any legal or ethical concerns. An unstated premise in the article is that the benefit to individual patients derives from their presumed inability to take responsibility for their own health, and an unidentified gap in the capacity of their personal medical caregivers to ensure that they receive quality medical attention. The article does refer, I have to concede, to what it calls potential complexities and ethical considerations, but it never identifies them, let alone addresses them. Indeed, immediately after noting these concerns, the article goes so far as to pose a potential solution. But it's not a solution to the ethical problems, but rather one which involves the linkage of national data sets, such as those associated with Medicare, the Pharmaceutical Benefits Scheme, hospitalisations at a state level, and the Therapeutic Goods Administration Adverse Event Database. There's no consideration in the article of the fact that this compartmentalisation of these data sets exists in part to protect privacy and ensure that particular types of personal information are only used for carefully specified and circumscribed purposes. And so in conclusion, what is the upshot of all of this? And I appreciate that I've covered a lot of ground and varied ground. It seems to me that the COVID-19 pandemic has not only tested our political institutions and our federal system in a profound way, it has also helped us to see areas in which our system of governance could be improved. Our statutory frameworks for addressing public health emergencies are sophisticated, complex, and ambitious, but they involve many moving parts, and a change in one part has implications for the others, often in highly ramifying ways. It is very difficult to keep up with them, especially at the interface between Commonwealth and state laws and policies. Provisions in the law intended to protect human rights, such as the right to privacy, can very easily be overlooked in a crisis. This is especially the case in a federal system like Australia's, where privacy protections are implemented at a federal level that can be undermined by state action. This is not an argument for or against the Commonwealth or the states as such, nor is it an argument against federalism, but it is to express concern that in the interstitial connections between the Commonwealth and the states, important protections can all too easily be sidetracked and nullified. This is especially the case when public policy is approached from the perspective of the hedgehog rather than the fox. The fox knows many things, but the hedgehog knows one big thing. The temptation for every hedgehog is to think that it is possible to devise a single grand plan capable of addressing complex problems effectively, efficiently and fairly, so long as enough resources are thrown at the problem. But as a fox, I'm not so sure this is always the case. Thank you.
Thank you very much, Nick. I think we're very grateful that you are a fox, I think, within Berlin's conception. You've given us many things to think about within the COVID frame, and with both breadth and depth, which I think is really helpful to give us some case studies to really think about these issues within. So thank you very much, Nick. I'd now like us to use the time that we have left to interrogate our speakers, Alan and Nicholas. I'm sure they're happy to answer questions. You can do that either using the chat function, and I'm happy to read out questions, or if you're comfortable, you're also able to use your microphone and put your hand up, and we can do it through that means as well. So I might just, while people are finding the necessary buttons and typing their questions, just use the chair's prerogative just to ask a first question, if that's okay. Alan, I know that you've written quite a bit about COVID and Australia's response sort of comparatively, and one of the things I've seen that you've observed is that the real friction that we've seen at points over the pandemic has been between the Commonwealth's desire to minimise economic disruption and the state's real focus on kind of containing the disease and how best to manage that. And I guess I'm just interested, on the eve of the federal election, or what we're expecting to be announced very, very soon, is to ask really whether you think this priority split was predictable, and whether it's really it's really given us a good sort of federal state balance in terms of that split.
Sarah, I think it was predictable. Whether I predicted it or not is another question, of course. I think it was predictable on two grounds. One is the very high degree of vertical fiscal imbalance means that the states have so little responsibility for revenue raising that they can quite easily leave that responsibility to the Commonwealth, and this makes Australia distinctive among the major federations. And the second is the ideological split means that with the coalition in government in Canberra having really nailed their flag to the mast of fiscal prudence and restoring the budget balance and so on, one would expect them to prioritise a more balanced approach. So I think it was eminently predictable and understandable from that point of view. I also tend to think that from an assessment point of view, it probably worked out fairly well. That it resulted in allowing a reasonably balanced approach in that sort of dialogue and political tension between the Commonwealth and the states was probably not a bad thing in terms of the outcome. That, of course, depends. I'm relatively agnostic on this, but some people have very firm views that on some of the more conservative commentators, for instance, think that we took far too prudential approach. And if you do take that, then you'll probably think that the states were too, had the benefit of too much irresponsibility, you might say. So that's a judgment call depending on where you come from ideologically.
Nick, would you like to make any observations on that?
It's very hard to add to what Alan has said. I think he's astutely, identified the issues in behind all of that. No, I don't actually have too much to add to it, Sarah.
No. Well, let's see if we've got any questions from the floor that we can direct. But anybody, I'm just having a look to see if we've got anyone's raising their hand and has a question or would like to come off mute and ask a question to Alan or Nicholas. Yes, we have a question here. Yes, Eugene, please go ahead.
Yes, I have a question for Nick, if I may. It's a narrow technical question, and you can dismiss it offhand if you think it's not relevant. But just drawing you back to what you said about the Commonwealth immunization thing, where it says it's fine to disclose if it's authorized under a law, let's say of a state or territory. And you mentioned the Northern Territory direction, but I'm just querying whether, based on what the High Court has said in Banyeri, Wooten, and most recently Palmer, that direction would actually be regarded as a law, because the court was quite clear about having to distinguish between laws and directions made under laws. So I'm just wondering what you think about that and whether that would pass muster under the immunization scheme.
Oh, thank you for your question. I was not suggesting that it wasn't a law. In fact, what I was drawing attention to was that it seemed like the Northern Territory had recognised the necessity of authorising it so as to comply with the Commonwealth law as such, and therefore to avoid any problem. And it was more to the point of drawing attention to the question whether other jurisdictions had gone to the trouble of doing that or not, to comply technically with what the Commonwealth law provided or required. Although I would add another, so yeah, that's the simple answer to your question. I'm not suggesting it doesn't have the status of the law for that purpose. I think the other dimension to it is that the Commonwealth law states very clearly what the purposes of the vaccination register are. It would be a bit of a stretch to suggest that those purposes could include the purposes for which that information was on occasion or quite often used at a state level in relation to admitting people onto premises. So there is a potential question even of inconsistency under Section 109 that might arise there as well. Look, I want to emphasise though, I'm raising these as questions rather than concluded views, partly because one of my points is that there are so many moving parts to this, and the legislation is so complex, and the states at a state level, the chief health officers have issued so many directions, and they've been revised so many times. I don't know, I'm sure many people here have tried to track them, that it's very hard to keep up. And so I'm not claiming that I've done an exhaustive search of the responses of the jurisdictions, and even in relation to Queensland, but it does seem to me that there's a gap. And into that gap, important protections and protections for privacy, which in the coolness of time, years ago, when we asked ourselves, well, this is a privacy interest that we ought to protect. Like Ulysses, we tied ourselves to the mast lest we be tempted by the sirens under the pressure of the moment. But of course, we know that when the sirens come by, they are so very seductive. And they're seductive because there are very strong reasons to respond strongly to a crisis. But one has to wonder whether, because of that, the protections that we thought were necessary when we had cool heads can be avoided or overlooked. And it especially, I think, is a problem in the Commonwealth state connection, because it's one thing for a government to make sure that its policies and its administration conform to its own laws, but it's a much more complex thing when a state needs to ensure that what it's doing conforms to the Commonwealth law in this technical sense that I've described.
So you reckon the state directions or the territory ones would be regarded as laws for the purposes of the immunisation register?
Yeah, I'm not questioning whether I would accept that as a premise. Yeah.
Okay, thank you, Nick.
I have another question from Yvonne, which was, has the WA government's approach on COVID reinforced the historic movement in WA for greater separatism or isolationism? I don't know, Alan, whether you want to start us off on that, being based in Western Australia.
Well, one thing, as a roundabout way of addressing it, is one of the most compelling events of the pandemic as far as federalism was concerned was the tremendous popular support premiers got for actions such as closing the borders and imposing rigorous measures and so on. And I think in general, what we've seen, what appears a recrudescence of a sort of aggressive statism or even secessionism, I think is really just a reflection of a general tendency for the populace at large to be supportive of, thankful of, grateful for kind of measures that narrowly protect them, even if it means at the cost of or prioritizing them, our community over the rest of the country. So I don't see it as particularly relevant to WA's distinctive characteristics.
I should just clarify that actually that was a comment made by Chris O'Meara, but he's using Yvonne's camera, so it came through as Yvonne. So
okay.
Thank you very much for that question, Chris. I don't know, Nick, whether you wanted to give a bit of an outsider's perspective on that, or whether there's anything you wanted to add.
Well, I think Alan can speak better for WA than any of us, although I suppose being in a federation, being bound by the federal bond, I suppose the perspective of other states and us in other states is also very relevant, isn't it? Because, and I would have to say that, look, I'm just speaking personally, nothing more than that, that the policy position the WA government has adopted did feel isolating in a sense, did feel that WA was separating itself from the rest of the states to an extent that wasn't happening elsewhere. And I say that even from the perspective of Queensland, which had pretty strict border controls as well. And probably people in New South Wales and Victoria looked at Queensland and Western Australia in a similar way and viewed them as separating themselves pretty strictly from them. And, you know, I certainly heard lots of people say, look, we're one nation. What's this idea of these border controls? You know, and of course they're people who are more conservative and, you know, questioning, I suppose, the policy response generally. But there's certainly people who were expressing that concern. But whether it's a move, you know, a shift towards a more secessionist stance, I think I agree with Alan. I don't think that it necessarily means that. I think there's a bit of a paradox. It's not always clear in a federation whether when one unit of a federation, in some sense, relatively gains more autonomy or is seen to exercise more autonomy, does that create sort of a slippery slope where that step towards greater autonomy is going to increase over time and eventually they're going to drift away? But it can have a paradoxical effect. It can be that, you know, once they feel that they are in a position to protect their interests and pursue their policies sufficiently, their interest in taking more extreme measures dissipates. And I think that whether you deal with a continuum or whether it's sufficient to hold a society together depends on a whole lot of other social and political factors that you can't really generalise about. And so that's a complex way of sort of pretty well agreeing with Alan, I think, on that point.
Just to add a little bit to that, Sarah, I think we have to keep in mind that the states vary in their objective circumstances as far as the viability of border controls are concerned. And of course, Western Australia had ideal circumstances for using that particular policy instrument, given geography, given that it is not dependent on any way on, for instance, tourism. I mean, not to say that there isn't a tourist industry here, but that it's not dependent to any significant degree on tourism, and that its exports continued unabated, and so on. So Western Australia was uniquely well situated to exploit that device that other states exploited as well, but just couldn't or didn't need to exploit to the same degree.
Yeah, I think Alan raises a very good point, and just one other small illustration to that list of reasons is the absence of significant border communities, because the border communities on the New South Wales, Queensland, and then Victoria, New South Wales borders are very, very significant. So special arrangements had to be made to accommodate business travel across those borders for people living in those border communities, which is very interesting because, of course, when the colonies federated more than 100 years ago, the interests and concerns of the border communities was a very major factor in the whole federation movement. So it says something quite important and even enduring about a federal system when you have that phenomenon of border communities in that way.
And there were horrible stories about people whose local hospital was on the other side of the state border between New South Wales and Queensland, for instance, and had an emergency or something like that. I mean, that just doesn't arise in the Western Australian case. So it is, they're distinctive, just material circumstances, really.
And
I don't think one should reach into it.
As you pointed out, Alan, it's different if you're dealing with bushfires, where borders aren't necessarily going to be respected in quite the same way, so it provide WA with quite a unique opportunity. I mean, Alan, you also made the comment that, National Cabinet to some degree wasn't such a hugely new innovation in many ways. I mean, I know that we kind of want to be at the end of the pandemic, but I think many of us kind of realising that we probably still have a way to go. But what role do you see National Cabinet sort of taking kind of as we move out of it? And, are we in a crisis mode, or do you think the patterns that have been put in place by National Cabinet are probably going to be a bit more long lasting?
I cannot see how they can be long lasting. I think federations in general are riven with such a range of difficulties, tensions over resources and policy priorities and so forth, that we can't pretend that they can be resolved by a sort of a war cabinet type arrangement, which is predicated entirely on a consensus of ends, for instance, and not just a consensus of ends, but a fairly high consensus of means as well, and of priorities. None of those obtain in a politics as normal situation. We will inevitably revert to something more like COAG for dealing with all the, in some ways, much bigger, much more difficult and much more contentious issues about school and hospital funding and infrastructure funding and all those sort of things that federalism, the bread and butter of federalism. We do have to keep in mind that the pandemic in some ways is a very easy political question to deal with. There have been some ideological aspects, but by and large, there is a broad consensus on what the end objective is with a pandemic. It's avoiding people getting sick and dying. In many public policy issues, there is no such simple agreement, consensus about what the very objective is. So this is a very old and straightforward public policy question, the pandemic. It was an easy challenge in that sense. And that's why you can get nice things like National Cabinet, where we're all mates. We can all every week get together and come up with a consensus conclusion about where to head to next. That is simply not possible under normal politics as normal circumstances. So it's to me, the answer is straightforward. Come back to me in a couple of years' time if I'm wrong, and I will apologize. But I'm going to put my money on it.
No, look, Nick, did you want to add anything to that, or are you happy to give Alan the last word?
I'm in strenuous agreement with him on this point. I say to my reluctance, but I do agree with Alan on it.
Fantastic.
This is 3 times you've said that, Nick.
I know. It's about that.
Look, I can't see that we have any more questions, and we're nearly out of time. So I think I might draw the seminar to a close, and if everyone could just use their reaction signs to thank Professor Aroney and Professor Fenner for their time, and we'll make sure that the recording of the session is put up on the AAL website for those of you who want to replay parts, or maybe for those of you who have missed it. But thank you very much to everybody, and please have a safe evening.
Thanks, Sarah.
Thank you very much.
Everyone.
Thank you, everyone. Thank you, Sarah, particularly. Good night, everyone.